Good evening. My name is Ethan Smith, and I would like to discuss with you this evening the implications of the Fourth Amendment to the United States Constitution on today's society. The Fourth Amendment to the Constitution states that it is, quote, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. End quote. Therefore, it is the intent of the Fourth Amendment to protect ordinary citizens such as you and I against unlawful searches by any governmentally funded protection agency such as the police. According to the United States courts, whether a search is considered unreasonable is determined by one of two factors. Quote, A, whether the search is an infringement upon an individual's Fourth Amendment rights, or B, whether there are legitimate government interests such as public safety. End quote. The extent to which an individual is protected by the Fourth Amendment depends, in part, on the location of the search or seizure. This justification was established by the court case Minnesota v. Carter. Heard by the Supreme Court in 1998 in a 6-3 decision for Minnesota, Chief Justice Rehnquist said that, quote, the people who visit someone's home for a short time do not have the same protection against unreasonable police searches and seizures as do the residents or their overnight guests, end quote. This ruling establishes that an individual's protection depends on, quote, the location of the search or seizure, end quote. Today, for a search to be conducted concerning your personal property, it is necessary for the agency conducting the search to possess a warrant granted by a judge. However, under certain circumstances, such as automobile searches and searching people under emergency situations, it is necessary for the agency to first obtain a warrant from a judge. According to the Constitution Center, quote, the way that the Fourth Amendment most commonly is put into practice today is in criminal proceedings. The Supreme Court decided in the mid-20th century that if the police seize evidence as part of an illegal search, the evidence cannot be admitted into court, end quote. Therefore, for evidence to be used against the accused in a court of law, the evidence must be obtained using a search warrant. One question asked by concerned citizens today concerning the Fourth Amendment is how does this apply to the cyber realm? Going forward, it will be very interesting to see how the court system interprets an aging Bill of Rights to answer questions concerning future advances. While there are varying instances in which the Fourth Amendment is put into practice today, the founders knew that a secured right, such as the right against unreasonable searches and seizures, would be needed to ensure a citizen's liberties in the future. Isn't it marvelous how forward-thinking the founders were to establish such freedoms ensured by the Bill of Rights? I hope you've enjoyed this brief presentation concerning a citizen's rights found within the Fourth Amendment. Thank you for your time, and I hope you continue to have a blessed semester